So what other freedoms does the Kentucky Constitution offer Kentuckians that Americans don't get to enjoy? Because there is an expansion of freedoms. There's also a lot of redundant freedoms too. So that's a question I want you to think about. And excuse me, I want to go to section 19 and 20 and section 9 and 12. I want to sort of sum up what I thought they all meant. Section 3, I wanted to mention something about Section 3 too. So the first 26 sections are Kentucky's Constitution. They're the Bill of Rights. The first 26 sections are Kentucky's Bill of Rights. And there's actually no way to add on to the Bill of Rights. It's not by amendment since they're sections, so they're already either put in there. You can add. There was an amendment where they added a section to another of the sections. Actually, 19. They added a whole paragraph to section 19 in 1988, which I'll get to in a second. So section 3 of Kentucky's Constitution is that men are equal. So they have that language, that everybody is created equal, everybody, under the law. No exclusive grant except for public services, property not to be exempted from taxation, and grants are revocable. Okay, so all men, when they form a social compact, are equal, and no grant of exclusive, separate, public emoluments or privileges shall be made to any man or set of men except in consideration of public services, and no property shall be exempt from taxation except as provided in this Constitution, and every grant of a franchise, privilege, or exemption shall remain subject to revocation, alteration, or amendment. So the first two clauses of this section appear with slightly different language. In previous constitutions, the framers of the current Constitution added the third and fourth clauses. In the original form, the first clause resembled those of other contemporary state constitutions, declared widely acceptable political theory about the inherent equality of men, most especially white adult men over 21 who had property. By the date of the fourth and last Constitution, however, this language was beginning to have the potential to grant a measure of equality to all men and women regardless of race and gender, although it would be some time before that condition would be constitutionally encouraged. The second clause also appeared in the Virginia Declaration of Rights of 1776. It may have been taken from that document. It seeks to prohibit individuals or groups of individuals from securing from government benefits that are not granted in receipt of public services. By 1890, many Kentuckians complained that in the charters the legislature had granted special privileges and tax immunities to a significant number of corporations. So Section 3, the addition of the third and fourth clause, that no property shall be taxed from or shall be exempt from taxation except provided in the Constitution. Every grant of a franchise, privilege, or exemption, so every grant of a business, every corporate charter shall remain subject to revocation, alteration, or amendment. So they can revoke it, they can alter it, or they can amend any fucking charters that they put out there. So by 1890, many Kentuckians complained in the charters the legislators had granted special privileges and tax immunities to a significant number of corporations. Although the U.S. Supreme Court had made it easier for states to revise and revoke corporate charters, reformers wanted to ensure that this could be constitutionally accomplished in the future by the legislature and other agencies of state government. Thus, the constitutional reformers inserted the third and fourth clauses in order to curtail special corporate privileges, including tax immunities. The Kentucky Supreme Court has declared that Section 3, together with Sections 1 and 2, embraces the Equal Protection Clause of the 14th Amendment of the Federal Constitution, Commonwealth Revenue Cabinet v. Smith, 1994, and the Court has suggested that when read with other state constitutional provisions, it might provide greater protection of individual liberties than the federal equivalent. Tabler v. Wallace, 1986, Perkins v. Northeastern Log Homes, 1991. The equal protection guarantees of Section 3 also form part of the rationale for the Kentucky Supreme Court's invalidation of the Commonwealth statutory criminalization of consensual deviate sexual intercourse, criminalization of consensual deviate sexual intercourse between persons of the same sex. Commonwealth versus Wassoon, 1992. Invalidation. So it says equal protection. You're not allowed to put, sodomy laws just against males if it's not against females. Despite these pronouncements, Section 3 has not been widely used to strike down government regulation of the economy. For example, Kentucky Court of Appeals upheld the state highway Department's complaint under the Kentucky Billboard Act against Express Mart Incorporated for maintaining a commercial billboard within view of the interstate highway, even though the company offered compelling evidence that the department enforced the statute more rigorously in wealthier communities. Commonwealth Transportation Cabinet versus Express Mart Incorporated, 1988. Similarly, the Kentucky Supreme Court upheld a tax on the gross revenue of medical providers despite claims it violated the equal protection requirements of Section 3, Commonwealth Revenue Cabinet v. Smith, 1994. However, there are exceptions to this pattern. The courts have similarly been lenient in their review of cases involving separate public emoluments. And I need to find what emoluments is. For example, as in Ballsworth v. Harp, where the pensions provided in 1912 to indignant Confederate soldiers were upheld because they were regarded as having been granted in return for public services. However, the Kentucky Court of Appeals did invalidate an amendment to a statute that authorized retirement allowance to be paid to circuit judges who had retired prior to the effective date of the original plan. Littleton v. Reed, 1970. So pensions provided to indignant Confederate soldiers were upheld because they were regarded as having been granted in return for public services. What the fuck? Public services, Section 3. But they do say that they're subject to revocation, alteration, or amendment. So that's all corporate charters are subject to revocation or amendment. Emolument, I've seen this. It's a salary, fee, or profit from employment or office. Emolument. So emolument is profit from the office. So the courts have similarly been lenient in the review of cases involving separate public emoluments, public profits. For example, in Ballsworth v. Harp, 1913, where pensions provided in 1912 to indignant Confederate soldiers were upheld because they were regarded as had been granted in return for public services. However, the Kentucky Court of Appeals did invalidate an amendment to a statute that authorized retirement allowance to be paid to circuit judges who had retired prior to the effective date of the original plan. So it's saying that it hasn't been used that much, but it is anti-corporation. So that's the Section 3 of Kentucky's Constitution. Section 19 is, they added the second section. So I'm just going to read the whole section, the Section 19. And it's really confusing language, but they explain some of it. So Section 19 used to be just ex post facto law, so law that comes after the fact, or law impairing contract forbidden. Rules of construction for mineral deeds relating to coal extraction. Number 1, no ex post facto law nor any law impairing the obligation of contracts shall be enacted. So once a contract is in void, you cannot have a legislature sitting there changing the fucking rules and laws to the contract. So once a contract is laid down, you can't be passing all these fucking laws that stops it. The second part of Section 19 goes to the rules for construction of mineral deeds relating to coal extraction. So, number 2, in any instrument heretofore or hereafter executed purporting to sever the surface and mineral estates or to grant a mineral estate or to grant a right to extract minerals which fails to state or describe and express in specific terms the method of coal extraction to be employed, or where said instrument contains language subordinating the surface estate to the mineral estate, it shall be held, in the absence of clear and convincing evidence to the contrary, that the intention of the parties to the instrument was that the coal be extracted only by method or methods of commercial coal extraction commonly known to be in use in Kentucky in the area affected at the time the instrument was executed, and that the mineral estate be dominant to the surface estate for the purposes of coal extraction by only the method or methods of commercial coal extraction commonly known to be in use in Kentucky in the area affected at the time the instrument was executed. So that was all about strip mining. So see, however, since the Civil War, as in the case of the federal prohibition, Kentucky's Contracts Clause has largely ceased to be an effective weapon against state regulation of the economy, as the courts have more narrowly construed the ambit of the clause and simultaneously enlarged the state's regulatory powers. See, for example, Commonwealth versus Covington and Cincinnati Bridge Company, 1893. An important exception to the generally limited use of Contracts Clause in modern times concerns legislative attempts to limit or prohibit the strip mining of coal. The Kentucky Supreme Court held in Akers v. Baldwin, 1987, that the Mineral Deed Act of 1984, which prohibited strip mining under the so-called broad form deeds, unconstitutionally impaired the obligation of contracts. Seeking to accomplish by constitutional amendment what it could not accomplish by statute, in 1988, the General Assembly submitted to the voters an amendment to Section 19 that added the second paragraph to the provision. The voters approved the amendment, which in effect prohibited strip mining under broad form deeds unless such mining was specifically agreed to. The Kentucky Supreme Court upheld the amendment, which had been challenged as a violation of the Federal Contracts Clause in the 5th and 14th Amendment of the Federal Constitution, Ward v. Harding in 1993. So they added a new section to the amendments, right? So you can add to the amendments, and it was all about the Contracts Clause, and the coal companies was trying to fight it, but actually the Kentucky people voted in favor of prohibiting strip mining unless it was actually specifically agreed to. So you can't buy a property, start strip mining it, and just shock the shit out of the person who sold it to you, who has the surface rights, or the neighbors. So you can only say, hey, I'm buying it for this, and I'm going to extract it in this way. I'm going to decapitate the mountain. I'm going to flood all the streams with all the chemicals. That's how I'm going to do it. So, you know, there, I told you, if you tell them right up front, then, you know, you're in the clear. But if you don't tell them up front, then they can get you for it, because you know, contracts, your contract is null and void. So Section 20. The Section 20 is like fucking fascinating to me, okay? So Section 20. Attainder, operation of restricted. No person shall be attainted of treason or felony by the General Assembly, and no attainder shall work corruption of blood, nor, except during the life of the offender, forfeiture of estate to the Commonwealth. This section has appeared in all 4 constitutions. It was divided into 2 separate sections in the first 3 documents. The term legislature was changed to General Assembly in the 2nd Constitution. The language originally was taken from the Pennsylvania Constitution of 1790. Technically, a bill of attainder is a special act of the legislature that imposes a death sentence on an individual accused of a major crime, such as treason, but without judicial determination of guilt. So Section 20 of Kentucky's Constitution can get the legislator to condemn some person, some citizen, to death for a major crime such as treason, without having any judicial determination of guilt. So the legislator could have a trial on its own and put someone to death for a major crime such as treason, or I guess murder, or any other major crime that could be committed. So that's what an attainder is. So no person shall be attainted of treason or felony by the General Assembly, and no attainder shall work corruption of blood, nor accept during the life of the offender forfeiture of the state to the Commonwealth. So it says it shall not be attainted of treason or felony. The Assembly cannot do that, and no attainder shall work corruption of blood. So, okay, so technically that's what a bill of attainder is, a special act of the legislature that imposes a death sentence on an individual accused of a major crime such as treason, but without judicial determination of guilt. In the 17th century, Parliament enacted bills of attainder to secure the official decapitation of allegedly treasonous royal councillors without having to involve the judiciary, which was thought to be under control of the king. Since that time, the judiciary has become more independent and is now regarded as the most preferred institution to determine guilt and punishment rather than the legislature, which too often proceeds without enforcing the necessary safeguards against prevailing prejudice and passion. So well established is this preference that the state and federal prohibitions against bills of attainder have seldom been litigated. In Arcerio versus Hager, 1965, the Kentucky Court of Appeals held that the prohibition only applies to criminal penalties, and thus a statute declaring that there is no legal relationship between an adopted child and its birth parents did not run afoul of Section 20, which I have no idea what the fuck that even means. It shall, no attainder shall work corruption of blood, nor except during the life of the offender forfeiture the state to the Commonwealth. So I have no fucking idea what this means. I'm still confused. No attainder, nobody can be put to death by the legislature shall work corruption of blood. So you can't do it against your own family. You can't like put an attainder on your own family or some shit. And they're talking about adopted child and its birth parents. So someone needs to explain Section 20 to me, because it's not that clear. But attainder is that the legislator can impose a death sentence, but it says no person shall be attainted of treason or felony by the General Assembly, so they can't do that. And no attainder shall work corruption of blood. I have no idea what that means, nor except during the life of the offender forfeiture of the state of the Commonwealth. So it's saying during the life of the offender forfeiture of the estate, so they have to give up the property to the Commonwealth, but during the life you can't have an attainder shall work corruption of blood. It's confusing. It's confusing. So the rights that Kentucky constitutions that actually give You get more Kentucky rights in Kentucky's Constitution because you got a right to be free from slavery. You have a right to immigrate out of the state. No hereditary nobility. No standing armies are allowed. You have a right to commit suicide without no punishment. You can never go to prison for a debt. The right to judicial remedy by the courts is upheld by everybody. Yes, I said you can never go to prison for debt. All cases indicted for felonies need to be brought before a grand jury. Juries decide libel cases, not the judge, and so much more coming up.